welcome. You're watching Head to Head on UATV, and I am Oles Gerduk. Today we're talking about Ukraine's judicial reform. Is it efficient enough? It's not a secret that it's a big problem for Ukrainians to find justice in the judiciary institutions. Paradox, right? Because of the intense corruption of judges, Europe is demanding the creation of an anti-corruption court in Ukraine. So far, we are lagging behind in this. And it's a different issue entirely to get your court decision executed once you won the case. To talk more about the issue, we welcome to the studio Dovydas Vitkauskas, team leader of the EU Project PRAVO-Justice. Hello, and thank you for coming.
Hello.
So, Mr. Vitkauskas, back in 2015, your project PRAVO-Justice, together with the Ministry of Justice of Ukraine and also with US aid, evaluated the situation with the Ukrainian judiciary right before the judiciary reform started in 2016. So, what was your assessment back then?
Well, one of the first steps our project did together with Ukrainian partners and international donors, we helped design a consultation mechanism under the auspices of administration of President, so-called Judicial Reform Council, which developed a strategy for justice sector reform, not only judiciary, but also all related institutions, including the bar, prosecution, Ministry of Justice, etc. And the strategy had a timeline of 2015 to 2020. And reform of the enforcement service was enshrined in the strategy as one of the primary objectives.
What sides needed to be reformed?
Well, when people go to court, of course, what they need is not a court decision. They need an actual, practical, and effective result of that court decision. And since majority of disputes relate to financial disputes between the parties, at the end of the day, the positive resolution of a court dispute is payment of money by the debtor to the creditor. So reforming enforcement is an essential prerequisite for court proceedings to be practical and effective, to have a result.
And until 2017, only 6% of a judgment in civil and economic lawsuits had been implemented. And your team, together with the other international experts, from what I know, recommended to establish a sector of private enforcement, right?
Correct. The state of affairs in enforcement of court decisions, especially in civil administrative process and commercial process, where, as I have mentioned, most of the disputes are about money, was deplorable. And according to different estimates, only 5% of cases, so you're not far away with your figure, only up to 5% of court decisions were actually timely enforced with regard to the creditor, with regard to the party that won the case. This compares to 5 and more times higher enforcement rate in European Union jurisdiction. So clearly something needed to be done about it. 5 to 10 times higher, I would say, depending on the jurisdiction. So something had to be done about it, and reforming the enforcement service was one of the steps that was agreed as part of the justice sector strategy. Ministry of Justice took the lead in the reform, but of course there were other stakeholders involved, including President's administration, who helped develop legislation, RADA, that helped pass legislation. So the legislation was passed in 2016, together with constitutional amendments, and the first private enforcement officers started operating last year.
Yeah, in the beginning of 2017.
Currently, we have more than 100 operational private enforcement officers in Ukraine who are functioning alongside the state enforcement officers. There are more than 4,000 state enforcement officers still today. But we moved from state-run system to what we have now, a mixed system of enforcement with private enforcement officers as an important element.
What is this aim of? What is the aim of this mixed system? To create the competition with the state enforcement, or what is the aim? One of
the biggest achievements in new EU member states, in post-communist countries, was privatization of the enforcement service. Justice reform is always difficult, it always takes time, but this was one of the areas where many countries moved forward. They dramatically increased the enforcement rates from 5% for instance, as we talked about, to 30, 40, 50%
and how did
of
it
the
change
total
the
court
situation
decision.
in Ukraine?
And the best way of doing that, based on the comparative experience from all these new EU member states and many post-communist countries, was to privatize the enforcement service, to create a private profession similar to the profession of a notary or a barrister, an advocate. So private enforcement officer is someone who has been delegated with the power of the state to collect the money with regard to the creditor or to enforce the court decision. The theory is that since private enforcement officer is an entrepreneur, he uses his entrepreneurial spirit to be more effective, to be quicker, to be more efficient. And take the money that belongs to the creditor according to the court decision. And this theory was proved by practice, by evidence of the reforms in other European Union countries. That's why Ukraine followed this path.
But still, 100 private enforcement officers sounds like not really enough for the whole territory of Ukraine. So how did it change the situation in 1 year of operating?
The data we have right now is very encouraging. If we compare the amount of closed cases and the cases where the creditor was actually paid, the private enforcement officers are showing efficiency which is almost 3 times higher than the efficiency of the state enforcement service. And this clearly follows the logic of the reform that I already described. So we already are seeing green shoots of evidence that private enforcement officers are going to be more effective and more efficient for the people, for the creditors who have won court cases. At the same time, you're absolutely right. We need to cover the whole territory of Ukraine. We need more private enforcement officers. We need them to compete between themselves and to compete with the state enforcement service. This competition will be the most important element that should bring the result to the users, to the creditors, to the people who have won court cases.
Mm-hmm. So how intense is the application process to become actually this private enforcement regulator? What is lacking
there are some statutory requirements, some minimum statutory requirements. This is a legal profession, so there are requirements as to education. Ministry of Justice has designed a rather complex system of access to the profession, which consists of an exam, testing, practical exercises, situational exercises with each of the candidates. The current ratio is about 20 to 30% of success. That means that only 20 to 30% of candidates who want to become private enforcement officers actually are passing the exams. I think this is a rather good example that Ministry of Justice is looking seriously as who enters the profession.
Mm-hmm. But how much does it cost to go through all this preparation course and the examination?
There are also preliminary initial training courses which are run by Ministry of Justice Institute, and the system is going to be changed. So some other schools in Ukraine, including universities, will be accredited to deliver those initial training courses. So a candidate needs to go through an initial training course. He needs to pass through all these complex exam stages, and at the end of the day, he is then registered, is licensed and registered in the private enforcement officer register. Becomes a private entrepreneur regulated by the state.
Mm-hmm. Could this be the reason that so far we have not enough private offices? This investment.
We have
basically
enough candidates already. Hundreds of people have registered since last year. Ministry of Justice has already filled in the whole exam schedule for the whole of 2018. So we do have enough candidates. But whether we have enough prepared candidates, whether we have enough good candidates to actually become enforcement officers still remains a question. As a policy target, Minister Petrenko has indicated that Ukraine needs to have up to 1,000 private enforcement officers within a year. So hopefully we will get closer to that target with the help of our project and other donors.
10 times more. Well, people often misunderstand, and they would consider private enforcement officer to be a collector. What's the difference between these terms?
It's a good question. Clearly, there are some limits to which private enforcement officer can act. Some of those limits are indicated in the legislation. The Ministry of Justice also has an oversight role including the power, for instance, to instigate disciplinary investigation, disciplinary proceedings against the person who might have abused his power. Courts also have certain degree of control, because the debtor, even when he loses the case, might still contest, might still question some of the elements in the enforcement process. So there are, let's call them, procedural safeguards to prevent abuse. At the same time, it is very important to encourage private enforcement officers to work properly. It is very important not to micromanage them, either by Ministry of Justice or the courts. In fact, if a debtor is contesting in court the enforcement proceedings, the courts should be very careful, because basically the debtor is asking to delay or maybe even negate the enforcement of a court decision that was taken before. So courts should have a very, very strict and very well-defined role in the control over the execution and enforcement of judgments. So these questions, I think, will still arise as we go. There will be obstacles to private enforcement officers, and we're working together with the Ministry of Justice and other counterparts to try to reduce that number of obstacles. For the time being, we have had very, very low number of complaints against the actions of private enforcement officers to compare with the number of complaints that come against the state enforcement officers. So hopefully this is going to be encouraging sign that will continue.
People are more motivated. But for instance, what procedures could these private officers do?
Well, for the time being, the mandate of private enforcement officers has been almost the same as the mandate of state enforcement officers, so enforcement in all civil and administrative and commercial cases, except for some narrow categories of cases, for instance, child custody. Child custody cases, because they concern some more serious and more specific and more delicate socio-psychological issues, were considered to be suitable only for the state enforcement officers for the time being. But if Ukraine follows the path of all EU member states, new European countries as well as old, which have private enforcement systems, in time Ukraine should equalize and to make the mandate of state and private systems the same. Second, Ukraine should probably move towards full privatization of enforcement service. What experience and practice in other European countries has shown is that mixed system is only a temporary stage before the state goes to fully privatize the system, simply because the private system gives better result at a lower cost for the user.
Thank you for your opinion. Now let's move into a different aspect of judicial reform. In January this year, the High Qualification Commission of Judges called upon your project, PRAVO-Justice, to assess the new procedure for selection of judges in Ukraine. So how does it comply with the European standards? So what are the results?
We were very actively involved together with High Qualification Commission and other Ukrainian partners in the selection of the Supreme Court last year. There were more than 1,000 of candidates. At the end of the day, more than 600 were allowed to take part in the competition. Half of those 650 candidates were filtered out and disallowed from the competition on the basis of testing, of legal skills and practical exercises. More than 300, if I remember correctly, 380 were allowed to the final interview stage, which was very important, with the participation of the civil society representatives, Public Integrity Council, with live streaming of interviews, and our project took part in particular in covering the services of psychological testing. So each of those 380 candidates were tested as far as their social and psychological skills are concerned. So at the end of the day, if you look at the complexity of the process and the complexity of the stages, if we compare this to what happened in Ukraine before, or to what's happening with judicial selection in other European jurisdictions, I think we can attest a rather high degree of transparency and objectiveness. At the same time, of course, there's still room for improvement. There's room for improvement to reduce discretion of the Commission in ranking the candidates. There's still room for improvement also to make the participation of the civil society a bit more constructive. I think both the Public Integrity Council and the High Qualification Commission still can work together to really make the process even more transparent and objective. But what we have seen last year was already very encouraging, both by way of history of Ukraine and by way of comparing the similar processes, analogous processes in other countries. So now this year Ukraine has to build on what happened last year, and of course there's big work ahead for the High Qualification Commission, the High Council of Justice and all the other counterparts. There's need to evaluate more than 4,000 judges. I think the number is close to 5,000, and this evaluation will be very similar to a competition, including all these complex stages of legal testing, social, psychological testing, interviews, civil society participation, etc. So it's a very big work ahead. New courts need to be set up. You mentioned anti-corruption court, but also there are other new courts that will be put in place. For instance, a specialized court on intellectual property matters, which will help resolve very important and very costly, time-consuming, highly technical and valuable disputes, especially for international counterparts with regard to intellectual property rights protection. So clearly there's a big work ahead, and we wish all the best for the Commission. And I think lessons from last year from the Supreme Court selection should be used to improve processes even more.
Well, thank you. And what could be your other recommendations on Ukraine's judicial reform?
Well, the justice sector consists of a variety of institutions which are checking on each other in a way. None of them have an absolute power. We call it the system of checks and balances. That means that at a certain stage, a certain institution comes with a new approach, with a new attitude, with a new objective. And I think this is the way justice is administered, by separating the powers, by having checks and balances, by having independent institutions throughout the process. This not only concerns the courts. Barristers, lawyers need to be independent to ensure quality service. Enforcement officers have to have a certain degree of independence to be effective for the client. Prosecutors need to be independent also in order to produce a service in the context of criminal justice. So it's a rather complex task. As I mentioned in the beginning, we have the roadmap, we have the framework, which is called the strategy 2015-2020. This strategy is itemized by a rather specific action plan. There's a big work ahead, and clearly the very fact that Ukrainian institutions are talking to each other, they're sitting behind the same table and discussing these policy targets together is already an encouraging sign. But we clearly still need to do more to really bring greater rule of law for the Ukrainian citizens.
Well, thank you so much for your contribution to Ukraine's judicial reform, and thanks for this interesting conversation.
Thank you.
That was Dovydas Vitkauskas, team leader of the EU Project PRAVO-Justice. Thank you for watching Head to Head. I'm Olas Gerjuk. Goodbye.